Subject to Interpretation, a podcast which takes us deep into the topics that matter to professional interpreters. My name is Maria Ceballos Wallis. Now, never stop learning is the motto of the De la Mora Institute of Interpretation. And in fact, it is also the reason why this podcast exists, to bring insight into the field of interpreting in all of its facets. So today we are going to talk to one of the most inquisitive interpreters I have ever had the pleasure to meet, and she has never stopped learning either. One who has had a stellar career in court interpretation spanning over 40 years. She has held many influential leadership roles, and in her own words, she makes the place and the time to stay current and productive. In this episode of our Founders Series in celebration of the De la Mora 25th anniversary, we're going to be speaking with Janis Palma. Welcome, Janis.
Maria, thank you so much for inviting me. It's always so much fun to see your podcast and now to be in one.
Well, that is wonderful. Now, viewers may remember that a couple of seasons ago, I interviewed you regarding your long career spanning many years, but specifically about the transition from freelance interpreter to full-time interpreter, supervisor, and then eventually again to freelance interpreter. So this time, I want to actually take a little journey with you, because you have been a really steady source of influence, a steady source of information and support from the interpretation community as far as court interpreting for many, many years. You were there close to the beginning of the of the federal interpretation exam, and your many roles gave you a bird's eye view of the evolution of this profession during that time. I want people to know that your experience not only includes the private sector, but it includes working in federal courts, it includes working in immigration courts, conference State Department, teaching, supervising interpreters. So you've done a little bit of everything, right?
I have. Yes, I have.
Now, tell me, when did you first become an interpreter? I think it was in Florida sometime in the 80s.
Yes, it was 1980. I just answered an ad in the newspaper and happened to land in this fabulous agency that taught me the very first basic things I needed to know about being an interpreter, and thank goodness, no bad habits. They were the ones who invited me to take the federal certification exam, and once I got certified, I got invited to go to federal court. And, after that was 1981. I've been doing it ever since.
Now, we've interviewed for this Founder Series, we've interviewed Holly Mickelson, Robert Jolie, and other people who have really been in this business a very long time. To set this into perspective, the Court Interpreters Act was passed in 1978. And that was the crucial moment which created the possibility for an interpreter certification at the federal level, right?
Yes. It took a little while once the law was enacted for the administrative office to put together the team that was going to develop the test, to pilot the test. And I remember the pilot was the one given before I took mine. So mine was like the very first for real test.
Did you know what to expect?
I had no idea. I went in there and the written one was like a GRE. And to me, that was like, okay, well, GRE, no problem. But for the oral, I had no idea what to expect. Everyone that had taken the pilot was telling me, oh, it's terrible. It's, this scary thing that you're going to go into. But I had no idea how important federal certification was going to be for the rest of my life. And so I wasn't worried. I wasn't anxious. I wasn't thinking, oh my God, I have to pass this test. No, I just went in there. They sent me. And took it and I thought, oh my, I had never done simultaneous. I said, there's no way I passed that test. But fortunately, I guess because it was the very first one, they were very kind-hearted, I guess. And I did pass.
Now, did you take this test in front of a panel or was your rendition recorded?
It was in front of a panel. It was a live panel of 3 examiners, and for the life of me, I cannot remember who they were. But there were 3 of them. And the only part that was recorded, I think, was the simultaneous. And we had these huge headsets, huge headphones to put on. The consecutive, they read, Q&A. One read the questions, the other one read the answers. And for the simultaneous, that was the only part that was recorded. And I remember to this day how big the headsets were. But it was rated by a panel until quite recently. The switch from having live examiners to having now everything recorded and then it's rated separately, that's a relatively recent thing. I still remember being an examiner and sitting in front of the candidates.
So at least 10 years, because when I started my process to become a federally certified interpreter was about 10 years ago. So at least 10 years forward, it's been recorded. Now, you also have NAGIT certification, which is something that a lot of people don't know anything about. And was that a recorded test or was that also a panel test?
That test was, let me try to remember, because it followed the same philosophy of the federal certification in terms of what we thought, NAGIT thought that the candidates needed to know at which level. I honestly don't remember if it was a panel of examiners or not. The one thing I do remember is that it tested simultaneous into English and it tested translation skills as well. So if you got certified by NAGIT, you were certified as an interpreter and a translator, and the interpreting and simultaneous was also in both directions.
Now, what year did you take this test, and what year did NAGIT stop giving this test, if you can recall? I'm not trying to put you on the spot here.
I'm trying to look at my NAGIT certification to see if I see a year, but I can't see from here. So early 90s was when it started to get developed, I think. I was not a part of the board that decided not to give it anymore, but I was, let me backtrack a little bit. I remember sitting in Miami for a NAGIT conference with Mirta Vidal and Dagoberto Rantia, and there we were arguing, well, should we have a society for the study of interpreting and translation? And what is this society going to look like? And what is it going to do? We need an academic arm of NAGIT, and we need this and we need that. So that was created. And then that was the part of NAGIT that was in charge of the testing, because NAGIT was still doing workshops and training. So you couldn't have the two things under the NAGIT umbrella. It had to be NAGIT trains, not for the exam necessarily, but whatever NAGIT does is educational, and then SSTI is going to be in charge of the test. I really can't tell you how many years it was offered or even how many people are currently certified by NAGIT and SSTI. But it was a labor of love to put that together. And in a sense, I feel like we've fallen out of step. Interpreters in the judiciary as compared to interpreters in the healthcare field, interpreters in education, they're putting together their own certification, their own credential. And we dropped the ball. We had a very, very, very good exam, a very, very good credential. And for some reason, somebody lacked the vision to see, hey, this is something that is going to help the profession. And they dropped the ball. What can I say?
Now I'm looking here at your resume and I'm seeing that you got your NAGIT certification in 2004, and that was actually quite a long time after you got your ATA certification.
Oh, yeah. Oh, yeah. In the 80s, I was taking my baby steps, so to speak. Like I said, I was certified in 81. I started working freelance, and then I became a staff interpreter, and then I was freelance again. But you have to remember that back then there was absolutely nothing for interpreters to learn, not even vocabulary. We had a glossary that was created by Sofia Saler in Los Angeles. And we had the Rob Legal Dictionary that I hope nobody uses anymore. There were no courses. There was nothing. I mean, Holly's Acebo was still in dreamland, I'm sure. So we had to be constantly teaching ourselves how to do things. And that's where this comes for me, always wanting to learn more and then sharing what I learned, because that's how things were when I started. And it just became a habit for me. I kept studying. I wanted to learn about not just language, because I had my studies in literature, and the theory in literature is essentially the same that you're going to use for interpreting. But I wanted to learn about semiotics. I wanted to read Umberto Eco. I wanted to learn about the theory of communication. And then I wanted to learn more about linguistics. And academia is not always friendly for, people who don't have a certain degree, and then you want to go for advanced studies in that field, and they're like, no, you don't have an undergraduate degree in that, or you don't have whatever. So I learned on my own. I look for the information on my own. And I still do. I read papers, all the time from different sources, because there's always something new that's coming out that is going to help you be a better interpreter.
Seems to me that nowadays we have a plethora of material available, of courses, training courses, whether they be online, synchronous, asynchronous. Let's go back to talking just a little bit about the associations before we move on to other topics. And can you paint us a picture of what the organization landscape was starting in the 80s and how you've seen that change? We've mentioned that you've got certification from the federal courts, from NAGIT, from the ATA. Let's talk about the organizations that existed and that were created over time, and how that has supported your journey as an interpreter and translator.
In the 80s, there was no internet. We didn't have computers. We had to meet each other by phone or going to conferences. And the main organizations that I remember are CITA, which then became NAGIT. That was the Court Interpreters and Translators Association. There was a California Court Interpreters Association, CCIA. There was an American Society of Interpreters, ASI, in DC. I don't remember ATA at the time, probably because it was more focused on translators than interpreters. But I'm sure that there's one or two more that I can't remember, but there were very few of us professional interpreters. So we would go to all the conferences, that were sponsored by these sister organizations. And by 1986, I was full in with CITA, later NAGIT. I was completely dedicated, committed to building up that organization. And so we would stay in touch by typing little newsletters with a typewriter and folding and putting a little piece of tape and the bulk rate, mailing rate or whatever. And that's how we stayed in touch. And we all kind of like knew each other. Everybody knew everybody. It was a very, very small family back then. And then of course there's been changes in every organization. Some of I'm thinking TALS. There was a TALS, TAALS also. And some of them have disappeared. Some of them have changed names. Some of them have changed the way of operating or their goals or whatever. And now, like you said, there's, just like there's a lot of training right now, there's a lot of organizations. Every state has an organization, pretty much every state. And so it's a little harder also to get to know everybody. And so I try to go to as many different gatherings, conferences as I possibly can, but it's hard because there's so many. So thank goodness for the internet now, and the way that we can see each other no matter where you are, no matter where I am. That's one of the advantages of the technology.
Now, I've noticed that sign language interpreter has a generalist category, and then it has specialties, but court interpreting in general just kind of seem to have bypassed this idea of a general skills interpreter category in favor of more specialized categories such as medical interpreting, court interpreting at different levels. One could say maybe that community interpreting or public service interpreting is a generalist, but it's always kind of been on its own as a category. Talk to me a little bit about that, and just in terms of the evolution that you've seen with court interpreting and medical interpreting and other areas bypassing the idea of this general interpreter
credential. The thing is, the way that I see it, the profession actually became a profession with the Court Interpreters Act in 1978. Before that, it was all ad hoc. It was all, you go interpret in a school, you go interpret at a church, at a gathering of academics or whatever you did other than diplomatic interpreting or conference interpreting at that level. Everything else was pretty much ad hoc. So professionalizing interpreting in the US took off with the Court Interpreters Act. So that was legal. That was all judiciary. And so kind of started midway as opposed to having the general category of interpreting and then specializing. It started with already a specialization. And then what I think has happened is that the other specialties have followed suit in terms of becoming more professional by having their own association, by having their own credential, by having their specialty courses. Because even if you can do the task of interpreting, of converting from one language to the other, you cannot do it unless you have the vocabulary and the terminology, the lexicon for that specific domain: healthcare, education, legal, and whatever else. Now, conference, by its very nature, I would say, is not specialized, because the conference interpreter is going to acquire and use the language, the vocabulary, the lexicon of the theme of the conference, whether it's dentists that are having their annual conference, or the World Meteorological Association organization, or whatever the theme of the conference, that's what the interpreter is going to develop for that conference in terms of knowledge. So in a sense, the conference interpreter would be the generalist, I guess, and that adapts depending on the subject matter of the conference. So they have to cover everything. There's no one thing that conference interpreters do unless they work for a specific organization. And then they would be doing the type of interpreting for that organization.
Now, do you feel one way or another regarding the idea of first maybe taking a few steps back and first creating a generalist spoken language interpreter credential? Or do you think the time has passed for that, and that wouldn't necessarily provide any more benefit than just jumping into the different domains?
I think that there is a different technique that each domain requires. So I don't think that you can do a general training. You can do general theory of, interpreting theory, but once you get into the practicum, I think that the healthcare interpreter has to use a technique that's going to be a little different from the one that the interpreter in education is going to use, a little different from the one that the interpreter in the legal setting is going to use, and even within the legal setting, there has to be also different techniques that you use depending on the environment. Are you in court? Are you out of court? Are you engaged in a are you interpreting for a witness during a highly contested litigation, or are you interpreting between counsel and the client? I mean, legal is really complex, I think, in terms of all the different scenarios in which you have to interpret. And I don't see anything in terms of practical training that could be general and then specialize in judiciary, for example, other than, like I said, the theory.
What about basic skills training, consecutive memory training, simultaneous decollage, sight translation techniques, things like that? I suppose maybe that's what you're talking about with theory.
No. When I'm talking about theory, I'm talking about understanding how language works, understanding how you process information, how your memory works, how your cognitive capacity is limited, and therefore you shouldn't be interpreting for 8 hours by yourself, things like that. I mean, there's theory behind all the things that now we know better than to do, which we did back in the 80s, like, work a whole trial by yourself. And in terms of learning retention, even that, I've given workshops where I advise interpreters to use different retention and note-taking techniques if they have an expert witness as opposed to a factual witness, because of the cognitive capacity to retain and transform a message accurately. So I don't know if you can do basic training in skills like simultaneous, consecutive, and sight translation. Well, maybe sight translation, but even simultaneous and consecutive, it's going to be different if you're if you have a witness, if you have an expert coming in, and it's happened to me, like a judge from Mexico who's going to be testifying, if you have an engineer who's going to be testifying about a failure of a bridge during a flood or something like that, your technique has to be different. You can't always use the same technique.
Would it be safe to say that you really had no idea what you were getting into when you applied for that position in Miami-Dade County?
Oh my goodness. I had no idea. I just thought I need a job. And here's a job that I can do. So let me go apply for it. And then when they said, you got it, can I tell you how much they paid back then?
Absolutely. I don't think we're violating any rules or anything like that.
$12.50 an hour. And I thought that was a fortune. 12.50 and I will never forget that. There's things I forget, but not that. And it wasn't, I mean, I started working for Dade County and a lot of the positions, but it was actually an agency in Miami that is very well known. And the woman who was in charge of training the interpreters has unfortunately passed away since then. But they were excellent people. You know, if you have nobody to teach you and then you get somebody who knows everything and teaches you to do it right, you are the luckiest person. And that's how I see myself. And for me, it's also what I do when I teach or when I write is a way of paying it back, because I was really fortunate to have had that opportunity and to have been trained in a way that I avoided a lot of mistakes that newbies do, because they're newbies, you know.
So it almost feels like this next conversation should be kind of like a speed round, because I'm going to ask you to talk to us about the changes that you have, that you witnessed in the interpreting professional over the time that let's just stick to the time that you were working as a staff court interpreter and then supervisor. Let's start with one of the one of the interesting comments you made in our last podcast, which said, when you said that interpreters were assigned to one judge, and then that changed because
yes, when I was well, let me clarify, my full-time staff position was in Puerto Rico, and that's a courthouse where about 98% of defendants need an interpreter. Very rarely will you have a case before a district judge or a magistrate judge that will not need an interpreter. So the custom, and not only in Puerto Rico, but in, I think, every district court that had staff interpreters, and there weren't that many, they would simply hire an interpreter for each judge. And that way they made sure the judge had an interpreter whenever he or she needed one. And
kind of like a court reporter, right?
I guess, yeah. So when I was hired to work for Judge Lafitte, who was the chief judge at the time. And I would go to court and come back and find that a few of my colleagues were there. And I may have been in court for several hours by myself. And I would ask them, and they say, "Oh no, we finished early. No, we're done." And I'm like, "What?" I had been a freelance interpreter in the Southern District of New York, Eastern District of New York, and the last one had been the DC Superior Court, and nobody worked by themselves. Everybody worked in teams. So I'm like, wait a minute, this is not right, I don't envision myself spending the next 15 years of my career working by myself in the courtroom and having colleagues that could work with me, but because either nobody thought about it, or I don't know, nobody wants to rock the boat or something. But of course, being an island also means that oftentimes interpreters and everybody else is isolated from what is happening here in the continental US. I was also very fortunate that one of my co-workers, my colleagues, was Tommy Cavalin. And Tommy had worked in California before coming to Puerto Rico, and he knew about team interpreting, and he was all for it. So I said, "Okay, Tommy, here's what we're going to do. You and I are going to go work together." "Really? Don't you think that's, people are going to react negatively?" I said, "Don't worry about it. Let's go." So we started to go to different courtrooms together. And the very first person to question was the courtroom deputy. So my answer was always, you know what? How would you feel if you had to spend like all morning talking nonstop? Don't you think you would get tired? Your brain would, like go into meltdown mode, and they're like, oh yeah, right. And that's just talking. We're transferring into another language. So little by little, we started to educate the courtroom deputies first, because they're like the gatekeepers. And, once all the courtroom deputies were on board, it was easy breezy from there on. We would just, whenever we knew there was going to be a trial or long calendar, whatever, two of us would go, no problem. And eventually it became the natural, normal thing to do. To this day, even if you have a long calendar, it doesn't have to be a trial or a hearing. A long calendar, it's going to take all morning with 4 sentencing hearings. You send 2 interpreters.
Now, team interpreting has been around for a while. How long do you think it's been around in the realm of court interpreting, at least in the federal? Because, let's be honest, it's not until recently that, for example, Najit had a paper on team interpreting, and that people have really started doing more in state courts and municipal courts than paying lip service to the idea of working in a team for a long hearing or a trial.
I don't know if I told you about my very first time in federal court. Right after I got my certification, I was called by the federal court in Miami, Southern District of Florida. I was sent to a trial, but not by myself. There was another interpreter there. There was equipment there, even though it was cables and wires all over the floor, but we had microphones. The defendants had headsets with receivers. So we had transmitters. It may have been Radio Shack, I don't know, but we had equipment and we worked in a team. And I was so grateful because I had never stepped foot in a federal court. So I just, watched and learned this other interpreter who worked with me. And again, for the life of me, I don't remember who it was, but I'm so grateful because I learned just watching this other interpreter working the trial. So at least since the federal certification, there's been team interpreting. Southern District of New York, team interpreting all the way. I think it was fortunate that there were some of the first interpreters to get certified who were staff, who had positions of authority as supervisors or coordinators, who had been conference interpreters, and they knew about working in tandem with other interpreters. So they immediately set the tone in these big courthouses in Miami, New York, probably California. I've never worked in California, but I imagine that they did that there too. So from the get-go, the big districts have had team interpreting.
It's interesting. You just reminded me of one of my very first assignments after being certified in Florida in about 2002. And I remember that I was sent by an agency to a deposition, and apparently the deposition was supposed to last well into the night hours, 9, 10, 11 o'clock at night. Nobody had bothered to tell me or anybody else. And I don't know if it was the fright of the idea of having to interpret from 9 o'clock in the morning to 10 o'clock at night, or if in fact I was getting sick. But the bottom line was that I started to lose my voice somewhere around 3 o'clock in the afternoon. And I had to call the agency. I said, I'm really sorry, I can't continue. But I had been there all day. And I started, that was kind of, it was kind of like a baptism by fire. I don't know who could have done that, but I'm guessing a lot of people find themselves that if they can do that, they find themselves that they think it's okay to be this kind of a, nonstop, invincible interpreter warrior. But I got to tell you, I didn't have it in me. It just, at about 3 o'clock in the afternoon, I was done. I probably didn't work for a week because my voice was completely shocked. I had no idea.
Let me tell you, sometime around 1983, 84, the administrative office of the U.S. courts had a training. And back then they invited staff and freelancers. They don't anymore. But the training was in San Antonio. And at the time I was in Brownsville. I was staff. That's when I met Dina Millman, who was Dina Cohn at the time. And Dina gave this talk about the do's and don'ts, which she doesn't remember, but I do. And one of the don'ts was don't try to be a hero. It's like, why? Why do you want to be the hero and work 9 hours by yourself or 3 hours by yourself? That was one of the big don'ts. And I always took it to heart. Don't try to be a hero.
I absolutely. And, recently I've gotten offers to work as to do depositions online, and they're like full day deposition online. I'm like, usually my response is thank you very much for your offer. Are you contemplating using a team for this assignment? Here, let me refer you to the NAJIT white paper on team interpreting. If you have any questions, I'd be happy to assist. I will be unable to assist you unless it is, a team effort.
And you know what's interesting is sometimes they say it's a matter of money, but then they go and hire a Czech interpreter. What is that? You're paying for 2 interpreters, you might as well have them working together. What is the point of having a Czech interpreter? Then you have one who is like dying because, that one interpreter has been working for 4 or 5 hours straight, and then the other one's just sitting there listening. Come on, it should not be a matter of money if you're going to have 2 interpreters there anyway for deposition. So I think interpreters should start asking, are you going to have a Czech interpreter? Yes. Okay, but then I want a team interpreter. I want a teammate. If you're going to pay for a Czech interpreter who's going to be doing nothing, I want somebody who's going to be working with me.
Yeah, I think I was probably scared off from the idea that I would get stuck in these, 4, 5, 6. I've probably, done 4, 5 hours without a choice. But, for freelance work, that's something that if you can avoid, and if something comes up to you, then you just
totally. And there was a time when we really didn't know any better. We really didn't. And that's the way things were done, and that's the way we did things, and we would go on and on and on for hours on end, trials one day after the next by ourselves. We didn't know any better, but now we do. Now there's no excuse.
Now, going back to your work in Puerto Rico, you started out as a staff interpreter, and at that time they were all staff interpreters, right? It wasn't until later that this notion of a supervisor appeared on the scene, right?
Right. There was a change in they did like a task assessment or of some sort, and they decided, first of all, that interpreters could not be evaluated like other members of the clerk's office staff, because interpreters fall under the clerk's office. And so they changed the interpreters from a GS to a JSP scale and added the supervisory position. So during the time that I had been a staff interpreter, and mind you, I had been freelancing for 20 years before that, and part of those 20 years were in Puerto Rico, there was one interpreter there, Ila Gutierrez, who had been doing the work of a supervisor without getting paid. She was doing all the extra work, and she wasn't getting paid anything extra. So when they approved this higher position for a supervisory interpreter, first of all, you needed to have at least 4 interpreters that you supervise. And of course, we had 8 or 7. We had 7 at the time. There's 8 now. So and I had been helping her with that because I love coming up with organizational stuff. It's, it's fun for me. So I was helping her with that, and the clerk of court called us in and said, okay, there's going to be this new position. And she said, and Janice, I want you to be the supervisory interpreter. And I said, Madam Clerk, Ila has been doing this work all these years. She should be the supervisory interpreter. And the clerk says, okay, here's what I'm going to do. I'm going to split it up between the two of you. And so Ila was able to get her supervisory position, and I was able to get the supervisory position for the rest of the years that Ila was there until she retired. And then when she retired, then that was it. There was just one supervisor. you know? But the truth of the matter is that there was no higher grade for her to go to. She had been there for forever and ever. So she had hit the top of the scale for the JSP that we had at the highest level. And it was really, I don't know. I don't know how to explain it. It was like a validation of the professionalism or the professional status of interpreters within the courts to have a supervisory position approved and assigned. That's the way I see it. It's like, okay, guys, you're not just glorified clerks, glorified bilingual clerks. You now have a management level position amongst you.
And I like the way you explain that, because it actually tracks with the evolution of interpreting across the board. First, it was, and in many places, and for example, in where I work, we are supervised by the clerk's office. But really, the day-to-day is on us. The minutia of actually knowing and understanding, what the needs are going to be, and possibly identifying some problems that may be occurring regarding volume of work and things like that, is up to the interpreters. And so by getting to the point where you actually have someone who can take care of that, who has the appropriate knowledge and who has the expertise of maximizing the use of the team, to me, it shows a huge evolution in the idea of, interpreters. They're not just random chess pieces. They need to work together as a team to provide for the entire court.
And there's also the internal culture of the clerk's office. And this is, I would say, in every court where there are staff interpreters. When the certification came about and interpreters were part of the staff in the clerk's office, they had a grade 5, maybe 6, but most of them were GS5. Once they got certified, they jumped to a 9 or a 10. And there was a lot of resentment from the other members of the clerk's office. And to this day, we're talking about 40 years later, there is still something left over from that. So to me, it was also important to have that seat at the table of management, so that it helps overcome that resentment, because, hey, this was not given to us. This is something that we earned, and we're here to stay, for one thing. And we're here to perform a professional function. It's been a journey for a lot of staff interpreters to deal with that resistance and resentment. And, well, if you're not in court, well, why don't you come over and help us punch holes in these papers, or, help us lick stamps or something. There's still a little bit of that, but it's dissipating. It's going away.
Now, switching tracks a little, because I have a whole bunch of questions for you still. It's always so interesting to speak with you, and we could probably, talk for another hour. But let's talk a little bit about the evolution of language and our understanding of the evolution of how you explain or how you conceive the idea of interpretation, in particularly with the simultaneous. So I think you know where I'm headed with this. I mean, in recent
Yes.
workshops, you know, we have been talking about omissions, what to omit, what not to omit. Are we, you know, speaking heresy when we talk about the fact that some things may or may not be omitted? Are we, you know, another topic which we discussed a while back is also, you know, the idea that that is not a Spanish word, or that is not a French word or a German word. And so there's just lots of things that surround the idea, not just of the evolution of language, because my daughter speaks in certain circumstances an English or a Spanish that I barely understand. And so the evolution of language, but also the evolution of the understanding of the interpreter, and by extension, the evolution of the techniques and the process the interpreter has to go through, right?
Okay, this has several stages. When the certification exam was first created in the federal courts, the people who worked on that certification, obviously not court interpreters. I believe there was one person in that whole team that had some experience working in courts, but most of them were either linguists, or they work for the Organization of American States, or they work for the UN, not for the courts. So creating the standards was more of a theoretical construct than actually based on the experience of working in the courts and interpreting in the courts. On the other hand, were those interpreters who have been basically thrown into the role of interpreting with no idea what they were doing, why they were doing it. And it's true, a lot of them were doing things like engaging in dialogues with the defendants or the witnesses ex parte, even given legal advice like, yeah, go ahead and plead guilty, it'll be a lot easier for you, that kind of thing, you know. There were a lot of interpreters, and this was part of Carlos's thesis study. A lot of people with no formal education in Spanish, so they did not have the vocabulary to interpret legal proceedings. And because of that set of circumstances, they created these parameters that interpreters are not to explain anything. Interpreters just have to repeat. And at first they were using a lot this term verbatim, which we now know is not what we do, but they wanted the verbatim. They wanted the interpreter to just say what they're saying, just repeat what they're saying, just translate what you hear, you know. And it like
Dreaded, Janice, the dreaded word by word.
yes, it's like the interpreter was a little machine, and you could, you know, take in all this information in English, and then you can spit it out in Spanish. And if it's a Q&A, then, you know, you can do it both ways. And it had a reason for being that way, but nobody thought, oh, no, I'm sorry. What they thought about the non-English speakers, which is how they were called back then, they were not called limited English proficient. What they thought about the non-English speakers is that they were going to behave just like the English speakers. They were going to understand everything just like the English speakers, just because they had an interpreter. And if they didn't understand, they were going to ask, like English speakers ask. And if they didn't understand, chances were the English speaker weren't understanding either. Nobody thought, well, if the judge speaks at 250 words a minute, the interpreter is speaking at least at 350 words a minute. So the person receiving the interpretation is not having the same time to process the information. The person who's hearing the information through an interpreter is not hearing all the different voices in the courtroom with the different intonations in the courtroom. They're just hearing one voice. And I like to call it, they're hearing the dub foreign film with the delay. So the lips move, but the words don't go with the lips. And it's just one voice. You know, it's a dub foreign film with just one voice and a delay. That's what the limited English proficient or the non-English speaker hears through the interpreter. That person is never ever going to be in the same position, in the same situation as the English speaker. Without getting into all the different aspects of culture, upbringing, different legal systems, without getting into any of that, it's just plain not the same thing. They're not here. And to think that a non-English speaker is going to ask for clarification, is going to interrupt the judge to say, I don't understand. I mean, I'm sorry, that's very ethnocentric, you know? It's like the whole world seen through the eyes of the Anglo-American English speaker. And that's not how the world works for non-English speakers in courts in the United States. But that has not been addressed since I'm going to say 1980, when they put out the first pilot exam. So we're still dealing with concepts from 40 years ago that don't reflect the reality of the courtroom, of the non-English speaker or the limited English proficient in the courtroom. And then because of this pressure on the interpreters with this code of ethics that has also evolved, it wasn't that the code of ethics back then was not like it is now. But before I get into that, interpreters were terrified to say the wrong thing, to use the wrong word, for people to think they did not have the knowledge in the target language to be able to interpret what the judge was saying or the attorneys were saying. So this tendency to raise the register of the target language more and more and more and more, to the point that now a lot of what is interpreted into Spanish, which is my language, I don't know about other languages, but into Spanish, is a higher register than the English. And that's because of this fear of God that has been put into interpreters not to lower the register. And then everybody wants to make sure that if somebody hears them, they hear them saying the right word in Spanish. So I'm not going to say troca. I'm not going to say marqueta. That's not Spanish.
And to non-Spanish speakers, what are those?
Like a truck or a market. I think it very much sounds like the word in English. But the thing is, who are you there for? You are there because back in 1973 or before, there was a decision in the Negron case that catapulted all of this. And the purpose of having the interpreter is for the person who doesn't speak the language of the court to be able to understand, to be present, to be able to cross-examine the witnesses against him or her, to be able to speak to the attorney, to assist in his own defense. These are due process rights that the interpreter is there because these people don't understand English. So let's make sure they understand what's going on. Instead of understanding what's going on, interpreters are making it more difficult for the person to understand because they keep raising the register in the target language. And they keep speaking as fast as, the English speaker is talking. English speakers are not going to slow down. If you don't learn how to deliver at a reasonable pace, then that person is not understanding anything. The problem is still there. There's no language access, there's no due process, there's nothing. And the 2012 edition of Fundamentals of Court Interpretation does say that in light of Executive Order 13166, which came about to clarify the 1964 Civil Rights Act, Title VI, that because of the trend that started from there to provide meaningful language access, interpreters have to take into account the listener. They have to consider what the listener understands. But that clashes with the old ideas when the federal certification exam was created. Different circumstances, different point in time, but the profession has not evolved to catch up with new standards, which are also supported by interpreting studies, the literature in the field, the what's being published in interpreting studies, which interpreters don't keep up with either.
Now, to be clear, when we're talking about this idea of the understanding, we're really talking about the simultaneous portion of the interpretation, the part where the interpreter is interpreting to the non-English speaker, the limited English proficient person that is not on the record.
Exactly.
When we're talking on the record, then that's a different technique, a completely different.
Exact. And that's why I was saying you need to teach different techniques to interpreters. It cannot be one technique for everything. On the witness stand, you need to have one technique because that's evidence. That's evidence that you are in charge of preserving for the record. But when you're interpreting for a defendant, then it's a matter of due process. That defendant has to understand. And the only person who can provide the assistance for that person to understand is the interpreter, nobody else. So if you're not doing it, then go home, because that's why you're supposed to be there.
Do you think conference interpreting techniques can be useful for court interpreters then, where there's a number of skills and tools that conference interpreters use, condensation, omissions of repetition, and a number of other skills? Can you?
Absolutely. At least things as basic as don't bother repeating synonyms. The defendant doesn't need to hear you repeat the synonyms, which are one of the things in legal language that comes from when English courts also had the French and the Norman and all these other languages. So that in order to make sure that everybody understood, they had 3 synonyms for everything. You don't need those in Spanish or probably in any other language. You can skip those. You can skip the incomplete sentences, the false starts. Let's say you start saying one thing and then you switch. You can skip all the hedging, the the ooh, the what, hey, you can skip all of that. Make it comprehensible, make it understandable. It doesn't mean that you change the content. It doesn't mean that you necessarily have to change the register either. But then if you do, so what? It's your job is to provide the language access for that person to have due process, to have a fair trial, a fair proceeding. Fairness is at the heart of all of this. And fairness means that if the interpreter is not conscious, aware of that person's ability to understand what you're saying, if you're alienating the person using a language that not even your fellow interpreter is going to understand, and I've heard them, things that I go like, what did you say? Then you're not fulfilling your duty as an interpreter. Your duty as an interpreter is to provide language access. It is not to parrot whatever the English speaker is saying. Oh, because the English speaker is not going to understand either. No, I'm sorry. The English speaker is listening to the judge at, let's say, 250 words a minute. Maybe it's not that much, but let's say it's 250 words a minute. Your defendant is listening to you at 350 words a minute. So no, that English speaker is going to understand. Your defendant is not, because you're speaking so fast and you don't know how to do it otherwise. You do need to learn techniques like condensation, for example. And for that, you need to know about language. You need to know what part of the sentence is redundant, what part of the sentence is essential. Interpreters need to know a lot more than they currently know in order to be able to do that. So we need education. We need a credentialing that takes that into account. We need a code of professional practice that is more in tune with what is happening right now, what we know. And then, of course, we need a practice that truly provides language access.
So that reminds me of situations where I've been in, and you know me, I have no problem, sharing my, my successes and my mishaps. But when I started thinking about that same subject was when you know how judges, when they're going to emit a ruling, it's in their brain and they just want to get it out, and that's when they start going to 1,000 miles an hour, and they're not considering anyone else. So then you have the interpreter interpreting this ruling, which could either be completely convoluted or terribly technical. And in the end, the interpreter, the person has gotten so confused that when the judge says, I find for the defendant, or I find for the plaintiff, or you'll be, guilty on these charges, and this is the sentence, the person says, okay, so what happened? Am I going to jail? Am I going to jail? And the person could have just been, he could have been found not guilty of all charges or something like that. So, and it happens. It happens probably more often than people would like to admit, because this is one of those moments when the legal professionals are, getting everything on the record, so that it can be preserved for possible future appeal should it be necessary. But this is the one moment this person has been waiting for, maybe for days, years, or hours. And all they're hearing is legal mumbo jumbo. All they want to know is, did I win? Did I lose? Am I going to jail? Any version thereof, right?
I'm going to give you two examples of a recent experience in court of how I am trying to develop a technique so that I'm not leaving information out. I'm conveying the question that the judge wants to convey, so the judge gets the answer that the judge is looking for. But there's two ways of doing it. Okay, so one example. Are you pleading guilty because you are in fact guilty and for no other reason? An English speaker is going to understand and is going to say, yes. A non-English speaker might say no, because the last part of the question is, and for no other reason. So this is one of those questions that I'm thinking, what is the judge thinking? I mean, what does he want to know? He wants to know if the person is pleading guilty because he is in fact guilty, right? That's what the judge wants to know. And the for no other reason is just reinforcing the idea you're pleading guilty because you are in fact guilty. So why? I don't understand the redundancy, but I know it's going to confuse the non-English speaker. So my rendition is, are you pleading guilty because you are guilty, or because you are in fact guilty? That's the question the judge wants to ask. That's the question I'm going to interpret. And the judge is going to get the answer that he's looking for.
Janice, some purists might take exception to that, right?
Yes, because I'm omitting something that the English speaker heard and the non-English speaker didn't hear. So what? So what? I am there to provide language access. I'm not there to be a parrot that doesn't think. And sometimes interpreters just don't think. They just like go on automatic pilot. I cannot go on automatic pilot. I have to be aware 1,000% of the time about my listener. Who is my listener? Who am I interpreting for? In both directions, not just the non-English speaker, also the English speaker. When I go back into English, I have to be aware of my listener. I want to make sure that that listener in English gets the right impression from this non-English speaker, rather than speak like a robot with no intonation. I have to be aware all the time of what's going on with the listener and with the speaker. And that means that sometimes I have to make certain adjustments. Here's another example. The prosecutor is showing the defendant a document that's called stipulation of facts. And did you read it? Did your attorney read it to you? Do you agree with everything that's in there? Is everything correct? Is this your signature? Blah, blah, blah. Okay, fine. So then the judge's turn. Are all the facts in the document you were just shown true and accurate? All right. So this is a stipulation of facts. Does the judge only want to know about the facts, or does the judge want to know that everything in that document is true and accurate? So I'm thinking the judge is using the word facts, but that doesn't mean that he's excluding everything else in the document. He's using a legal phraseology. If I go to the Spanish speaker and say, are all the facts contained in this document true and accurate? Most chances are I'm going to confuse the person. So if I ask, is everything contained in this document true and accurate? It is the same question that the judge is asking, but I'm leaving out the confusing part, which is, are all the facts true and accurate? Because I know, because I'm using my brain, the judge is not just asking about the facts in the document. The judge wants to know if everything in there is correct, is true. And I would be doing a disservice to the judge and to the non-English speaker if I try to be so literal that I am causing confusion. But I know that is not the dogma. The dogma is you repeat everything that the English speaker would have heard. Well, the English speaker would not have been confused by that question. At least I don't think so.
So speaking of dogma, how to say it, but I mean, I think you put your money where your mouth is. Let's say it that way, because we see a lot of blogs from you, Najit blogs, and some of them are about privilege, some of them are about rules of evidence, they're about different legal topics. You are in fact in the middle of a master's program in legal studies and working your way towards a PhD. So it's not like you're making this stuff up or creating an interpretation. You're actually studying this with other legal scholars, correct?
Yes. But the theory about interpreting in legal settings is something that I have been developing, because obviously my professors don't even think about the interpreters. I have to keep reminding them, hey, don't forget about the interpreter. Don't forget about Rule 604. So this is something that I am developing as, just like I developed my knowledge in the very beginning when there was nothing to train interpreters and we created materials and we created courses. Well, now I'm creating a theory and a practice, because I'm doing it. I'm putting it into practice with actual defendants and testing it and seeing, at the end, they all say, yes, we understood perfectly well. I don't see the faces that I used to see before I retired. And how this whole thing started was my concern that I would finish and the look on their faces was like, what just happened? Like you were saying, what just happened? Now I see the understanding in their faces. I see that everything is clear for them, and I feel like, okay, I did my job today. I assisted in the communication between this judge and this defendant, and they understood each other. And this person is going to go back with the marshals, but he's going to know what happened here today.
So in addition to the studying that you're doing, so you're still an active interpreter after all these years.
Oh, yeah. Oh, yes. Yes, absolutely. I don't think I will ever stop interpreting unless, I lose my mind or something. But I like it. I like interpreting. And as you just saw, I have a lot of work still to do. I have a lot of theoretical work that I want to do, but I also want to put it in practice. I also want to see how it works,
What about now that you're no longer on the NAGIT board again, which, you've cycled on and off over, 20, 30 years a couple of times and have participated with other organizations around the country. Now you've created your own organization because you really are committed to building the next generation of court interpreters that are trained and that are supported. What is Ikigai?
I saw that word and it's in my heart. I felt this is going to be the name for my nonprofit. And it's about finding your path in life, your destiny in life, what you're meant to do. And this is what I feel is my mission, what makes me happy. It makes me happy to help other interpreters be better. It just, like I said, maybe it's a pay it forward thing, but I really get a lot of satisfaction out of helping other interpreters, even the slightest little thing, like maybe just suggest one word. When the judge says, how do you spell your name? Instead of using the word spell in your target language, maybe the best word is write or say, and if I make that little suggestion to someone and that helps that interpreter do things better next time, I'm happy. But with Ikigai, what I want to do is not just train in this new theory, but I also want to help interpreters get a credential. Let's put it that way. And so I'm putting together a team so that we can have a scholarship fund and we can start to sponsor younger interpreters who have not been able to get certified because they can't afford the certification cost, which can be very expensive in some states. And like you said, build a new generation of interpreters.
Janis, it really feels like we've barely scratched the surface of your experience, your projects, and the impact that you have had over the interpreting profession and will continue to have. Thank you so much for being here on Subject to Interpretation. We really, really appreciate your candor, and we look forward to seeing what's next for you.
Well, thank you, Maria. I really, really enjoy our conversations. I had a great time here with you today. And for the next one, maybe I'll be able to talk about the book that I'm working on, which hopefully will also be my dissertation project. So we're holding off on that till next time.
We certainly look forward to having you back on our program to discuss your dissertation and also to talk about what new adventures you've been on, what new innovations you are crafting for the world of interpreting. So thank you very much for being with us.
Thank you.
And to our audience, thank you very much for joining us here on Subject to Interpretation. If there's a topic that you would like to have us cover, please feel free to email us at podcast@delamorainstitute.com. Now, remember that this is the 25th anniversary of the De La Mora Institute of Interpretation, and you're welcome to check out all our past episodes online and on the podcast platforms. Thanks for joining us, and never stop learning.